So, as some of you know, I'm an attorney in what we call real life. So, I just had to dispel some myths and inaccuracies that are being passed around in the media and just highlight another issue that I see in the Kenosha Kid trial. But first, looking at this film set issue, it seems all the public discussion on this revolves around who was the individual who put a live cartridge in the firearm. And now I just heard a statement on behalf of the armorer that they have no idea how a live round ended up in a box of blanks. They think that it was dropped there by accident. So I guess first of all, the point I want to make is literally everything I've heard so far about this case is irrelevant. From what I know from people who have served as armorers on set and from what the basic rules of gun safety dictate, rules of agency and everything else, you hire somebody to check and load firearms on a movie set. They're responsible for every round that goes into that firearm on a movie set. So the fact that somebody may have dropped some 40 caliber in a box of 9 doesn't absolve you of liability for sticking the wrong round in a pistol and handing it to somebody else to shoot and have it explode in their hand. So it just seems to me that the entire public discussion on this has been irrelevant. Secondary, everybody keeps talking about the fact that somebody handed a loaded firearm to a actor as if the actor has no responsibility for pulling the trigger. I'm glad to hear from many people out there who have served as armorers on set that the actors are trained and taught how to check a firearm and make sure it's loaded the way it's supposed to be loaded, whether it's blanks, make sure there's no live munition, make sure if there's supposed to be dummy rounds, there's dummy rounds. I've also been seeing a lot of clips online of interviews of action movie type actors who say the same thing, that they're trained in firearm handling and safety and to check the chamber to make sure it's loaded properly. So again, I just don't know the relevance of saying somebody handed an actor a gun and told him it was safe or it was a cold gun as if that absolves him his liability. I got to tell you, if I were to hand a firearm to somebody else and they started pointing it around at people and pulling the trigger, they're going to be prosecuted for that. If you go to a gun range, they hand you a firearm, a rental, it's presumed that it's loaded, it's a firearm. And if, they don't, make sure it's unloaded when they hand it to you, unloaded until it gets to the port, there's liability there. And that's why we have RSOs at ranges to watch the activity there. It's just, basic firearm safety. If somebody picks up a friend's concealed carry firearm, points it around, starts pulling the trigger, the prosecution isn't going to say, well, he didn't load it himself, somebody else loaded it, so they have no liability. No, which was kind of dumbfounding to me when the county prosecutor said this was a case of first impression, that they have never had a case where somebody handed somebody else a firearm and that person started pulling the trigger and pointing it around. Well, I think you just described 25% of negligent discharges out there in the world. So that just seems kind of stupid. A lot of negligent discharges are cases where somebody unfamiliar with firearm safety picked up a firearm and just assumed it was unloaded, assumed the owner of it kept it unloaded. That's just not how it works in real life. So here we have a situation where we have somebody who has decades of experience with handling firearms on movie sets, and we have to presume at one point or the other he was educated and given the information necessary to know you have to check the firearm yourself, make sure it's clear or whatnot. So whether or not he pulled the trigger after the camera was rolling, during rehearsal, or in jest, kind of trying to tease them and fire a couple blanks at them to startle them, it's wholly irrelevant. Which brings me to the next point. So some people think, oh, this will get settled and worked out in the courts, justice will prevail. Yeah, I've been practicing for 20 years. There's no such thing at this point. So case in point, I don't know if anybody watched the first day of testimony in the Kenosha Kid trial, but I mean, it should scare you a little bit that the prosecutor was arguing that since the Kenosha Kid had a sling, his claim that the person who was running after him, both one with a skateboard and the other one with a loaded pistol, that these people running after him couldn't have gotten the rifle off of him because he was wearing a sling. And the purpose of the sling is to hold the rifle, quote unquote, close to your body. Well, I'm not sure how you wear your sling, but the sling has to be loose enough to get the firearm up, mounted and shouldered in shooting position. And these, and I'm sure the defense probably won't bring an expert in to say this, but they should, that these slings are made with a fail point, whether it's an area of stitching, whether it's a plastic buckle that's meant to break. Let's be honest, if you're walking down the street on patrol and you get hooked by the mirror on an 18-wheeler, you better sure as shit hope that strap fails before your head gets ripped off your body. So that's one thing, but the bigger point is this prosecutor is trying to convince a jury that you don't have a claim of self-defense if somebody's trying to overpower you. No, if a mob of multiple people are trying to overpower you, steal your firearm from you to use it against you, that's not justification, and you didn't have a reasonable fear of grave injury or death because you had a sling, so therefore nobody could get that firearm off your body. Even if they beat you to a pulp, even if they knock you unconscious, there's no way they can get that firearm off your body and use it against you. Well, first of all, I think I could get that firearm off half the people out there. And if I were the defense attorney, I would have asked that prosecutor to sling that firearm over his body. And then I would have proceeded to demonstrate for the jury just how easy it is to dispossess somebody of a firearm, even if it has a sling. Or I just would have reached over to the QD link, pushed the button, and pulled the sling off. I mean, just absolutely ridiculous. And people, you have to understand, yes, you have an absolute constitutional civil right to defend yourself with a firearm. But just know that there are prosecutors out there, many prosecutors out there, who are going to act in a political manner and who are going to prosecute you just because they're anti-gun. Case in point, my advanced writing requirement for my law school was a case study of a woman in Newark, New Jersey, whose estranged husband was beating down the door, hopped up on drugs, to beat her up and possibly kill her. So what does she do? She retreats to her son's bedroom, shuts the door. The estranged husband proceeds to bash through the door and continue to proceed towards her. She grabs her son's hunting rifle, and while cowering in the corner with nowhere else to retreat to, fires a shot and kills her estranged husband. They prosecuted her. They convicted her of murder. It's insane. It took an appeal of this case up to the New Jersey Supreme Court. And even then, since she herself passed away, the state tried to argue, the case is moot. She's passed away. We don't need to decide this. Well, kudos for the New Jersey Supreme Court for taking that case anyway and saying, no, the case is not moot. We're going to hear it. And they were pretty damning of the prosecutors for even bringing that case in the first instance. So, I hear cases all the time. I was at a conference once and a detective from the state police came and told the crowd, it's okay to have loaded magazines separated from your firearm while you're transporting them to the range. Yeah, no, it's not. Because there are prosecutors out there who will prosecute you for that case, and then the state will try to get you to use your one-time pretrial intervention, use that up to get the charges to go away. It's insane. Who wants to go to trial and sit in front of a jury and have a full trial on something that a representative of the state police told you was perfectly legal? We also had that case in New Jersey where somebody had ammunition in the car, and they were a specific type of ammunition that is manufactured in a way that even the state police website said Hornady Critical Defense is not a hollow point because the front cavity is filled with this polymer insert. Well, guess what? There are people who have been arrested and prosecuted for possession of hollow point ammunition when they had the exact type of ammunition that was up on the state police website saying it was perfectly legal and not considered hollow point, so you can transport it, at times other than when you're going to and from the range. So just keep that in mind, everyone, when you're listening, to the news on this, and if you're watching the prosecution's case and you're sitting there scratching your head going, well, wait a minute, I don't understand that as one of the basic tenets of gun safety. Yeah, I'm here to tell you it doesn't matter. They can argue whatever they want in court. There's no legally judicially accepted rules on gun safety. We can follow the NRA, the NSSF, and other rules that even Hollywood teaches to their actors. We can all follow them and say that that's the standard, that's the reasonable person, and that's the duty of care. But these prosecutors can get up there and argue anything they want. Other prosecutors can say, well, it really wasn't his fault because, he didn't know to check the chamber himself before he pointed a real firearm at people and started pulling the trigger. I mean, to most of us, that would seem asinine. But, don't be too frustrated, when the prosecution, doesn't act. And then, people in Hollywood continue to attack you if you use a firearm in self-defense, or, if you're a certain U.S. senator who had a negligent discharge fired around into the floor, they said he should have been prosecuted and he should have been stripped of his Second Amendment rights. But here they are arguing that an actor who purposely pointed a firearm at somebody and pulled the trigger without checking the chamber himself, it was a horrible accident, and he shares no responsibility. That's just how it works, and I just wanted to put that out there from a legal perspective. What may seem, a slam dunk to you or I, because you have decades of experience in this area, and what we preach for years and years when it comes to safe handling of firearms, and what it's like, what it would be like to have a crowd of people chasing you with weapons and firearms on their own to defend yourself, just to have a prosecutor say, well, no, even if you were beaten to a bloody pulp and left unconscious, they still wouldn't have been able to get that firearm off your body because it had a 1-inch piece of nylon that had quick detach buckles on it, for Christ's sake, and plastic connectors. No, they couldn't have gotten that off your body. Sorry to say, but that's the reality of things. So if anybody has questions, just drop a comment below and I'll try to address them if I can. But basically the answer to any legal question today is, well, it depends. It depends on who the prosecutor is. It depends on who the jury is. And I think that's unfortunate. So sorry for the long video. Matthew, the average gun owner, I hope you learned something today.